All right, the next case this morning is Bauer versus Morgan Stanley.
May it please the court, my name is Bob Dyer with the Orlando firm of Allen, Dyer, Doppelt, Milbrath, and Gilchrist, and I would like to reserve 5 minutes. This case began with the filing of an arbitration back in 2003. This elderly couple, who have since become about 7 years older, he's in his low 80s, 82, 83, and she's 79 to 80 right now. It was a $50,000 award. The evidence would have shown well over $200,000 in damages. That happens with arbitration, especially industry arbitration. You never quite know what's going to happen. But within a year, or about a year and 2 months, we had another arbitration involving the same broker from Mount Dora, William Smathers. And what do you know? We got about 6 inches of discovery that revealed the full background of this broker. Going back to 1995, the little Mount Dora office, which is a satellite office with a kind of an assistant manager, it's really managed out of Orlando, couldn't control them. But
we're familiar, Mr. Dyer, with the facts of the case. The issue ultimately resolves here around whether there was a requirement to go back and try to set aside the arbitration based upon fraud, based upon the failure to provide this discovery, and in fact, not just a failure to provide it, but apparently Morgan Stanley actively concealing and calling a spade, lying about the existence of emails, claiming that they all had been destroyed on 9/11. But there never was any attempt to go back to set aside the arbitration. And the law that in this area seems to be fairly clear that that's what you need to do.
Well, in some circumstances. First of all, nobody knew. This was a massive, hundreds and millions of emails were said to be destroyed, and this went on for 3.5 years until the NASD caught it, which is now FINRA. And when they did, they fined the company $15 million, pointed out they had a history of violating all kinds of discovery requirements. And so the judge in the lower court said we should have employed a fiction. It says, but they argue that you weren't time barred because the 3-month statute of limitations, that's the period within which you can challenge an actual arbitration, was told by their wrongdoing. And if you had done that, he would have given you a remedy. Well, okay. The only problem is Morgan Stanley, and I think it's really an industry position, they don't accept the possibility of tolling. If 3 months go by, then no matter what the fraud is.
It doesn't matter what Morgan Stanley accepts, it's what the court accepts. And there is some case law out there that indicates that tolling can be utilized, some federal circuit court cases, and indicating that the time frame of 90 days is not jurisdictional. So what Morgan Stanley thinks is really irrelevant. It's what a court thinks, whether they would have granted your client the right to go back and set aside the arbitration award even if it's more than 90 days. And here we don't know what the trial judge may have done or what we may have done. But I guess my question to you is there's several cases around the country that say the exclusive remedy is to go and vacate the arbitration award and you may not bring an independent action. Are you aware of any cases which have gone to the contrary, or would we be the first if we accepted your argument?
Well, I don't think it would be the first.
Cite me a case.
The Episcopal Diocese case from right here.
That case dealt with whether the subject matter, whether the dispute was subject to arbitration at all.
That's right.
That's a totally different issue.
But it was raised as if it had to be brought under Prudential's arbitration agreement. So you have the same issue for one aspect. How can you possibly say that this nationwide 3.5-year deception fits under any arbitration agreement? They haven't shown the language of this arbitration agreement, how it would fit.
The damages that you seek are what?
Well, the damages would be the delay in getting compensation,
Right.
the delay, and you would get punitive damages, and you would get a whole range of interest. Yes, you would probably also have your original damages, but it's a mixed bag. It's 2 or 3 different elements of damage. Here's the thing. They can send us back to arbitration, but the lower court said, as you're familiar, that this court agrees that the act to set aside must be brought under the federal or the state arbitration code. The arbitration agreement in the case at BAUER is basically common law arbitration. That doesn't relate to federal or state. In reaching this conclusion, the court rejected plaintiffs' contentions that they have an entirely separate and independent cause of action that can be asserted in this forum. Now, where do you assert it then? That raises the question. Now, the Hornsby case that they relied on for some tangential issue points out that they can have a motion, but it must be filed not before a different arbitration forum, but in federal court. The problem is, very simply, you cannot have any industry run a deception for 3.5 years and then say you had to do something within 3 months. That's too much cover for the industry, and that's really what Morgan Stanley is pushing. So the court below said, well, there's no independent cause of action. And that is as much as saying that you are excused if you can get by for 3.5 months. I find that very difficult to accept.
Let me ask you this. If your clients have found out 45 days after the arbitration award, would your exclusive remedy be to vacate the arbitration?
I think so.
Okay. So if it's more than 90, but you could toll, why would it be any different?
Well, if you can toll, send us back, because they resist tolling. Ask them point blank.
But again, what they say doesn't matter. I mean,
I understand.
I assume their view is they shouldn't have to pay you any money.
Well, of
but
course.
they don't get to decide that. So, it just seems to me that the way to do this is you seek to vacate. If the arbitrator says, no, you're too late, then we have an issue, or the trial judge has an issue, should tolling have been allowed. But if you don't even seek it, it's hard for me, if it's an exclusive remedy in less than 90 days, and you may well have been able to bring it after 90 days, then why shouldn't it be an exclusive remedy there as well? Well,
let's look at it this way to try to answer that question. I don't know of these 2 cases that they cite and that were brought up in the hearing before Judge Smith, and that is the Pisciata case that they allude to tolling, and the Hornsby case that talks about tolling. But there the court said the issue isn't right because the plaintiff was in before another arbitration forum. If there's tolling, then we would have to be sent back to arbitration. But it needs to be clear in the decision, because Morgan Stanley will get up here and say no tolling.
You haven't sought that. You know, what we have here is the filing of an independent action. It's not the filing of a motion to vacate the arbitration award and a ruling from a lower court, yea or nay. You filed an independent action, and that's the status that we have now. I don't think that we have any authority to remand this case in terms of the arbitration award. Assuming that we don't see the Episcopal case, the Episcopal Diocese case, quite the same way that you see it, do you have any other cases that hold for the proposition that you are asserting, which is that you can bring an independent action as opposed to an action to vacate the arbitration award?
I think it's the Episcopal case. And there, remember, even though the damage took place down the road at another brokerage firm, Prudential is the one that ultimately had to pay because it didn't fit under the arbitration agreement. They have never, in this case, in this record, tried to show that this kind of fraud that went on for 3.5 years to hundreds of claimants could be made to fit under any arbitration agreement. That's the problem. And you can only stuff into an arbitration agreement what the parties agree to. That's the teaching of the Episcopal case. And if it doesn't fit, it's contract law. The world isn't governed by arbitration law. Arbitration is only contract law when you get right down to it. If it doesn't fit, it's not arbitrable. And this court has held that. The Supreme Court of Florida in a Modio case held that. So you have a choice. How can they get away with that kind of fraud that couldn't possibly be contemplated by any arbitration? Can you imagine them writing an arbitration agreement that covered all our future fraud? The NASD and the SEC would not allow those kind of agreements, but that's what they're going to have to say. Stop and think about it. How do you fit it in that bottle? And I don't believe you can really do it. It isn't going to upset the world in arbitration. At the outset of our reply brief, we said we're not trying to upset arbitration law. I've been doing this for nearly 40 years. Securities arbitration. You get very few challenges. Episcopal Diocese was one. This is another. But the world isn't going to come to an end. But you must find a way in the context of this record to say on this arbitration agreement, remember, they haven't tried to show the language and how they get there, that this massive fraud easily fits into a common law arbitration provision. If you can show that, or they can show that, then maybe I'm in the wrong forum. But I don't know how the industry can get that kind of cover. I'll reserve the rest.
May it please the Court, Joseph Coates of Greenberg Traury representing the appellees in the case. If I may, members of the Court, address the last issue raised by opposing counsel, which is the issue as to whether there's an arbitration agreement that applies to this particular matter. The answer is yes, emphatically there is an arbitration agreement that applies. What counsel overlooks is the fact that he filed a second arbitration proceeding, voluntarily submitting this very dispute below to arbitration.
Let me ask you this. If it took 180 days for them to reasonably learn that your client had committed fraud in discovery in the arbitration proceeding, would the statute limit, would the 90-day requirement under the federal statute be told?
Under the federal statute, there is no case law that addresses that directly.
But you're arguing to us, I take it, that they should go to vacate the first award.
Absolutely.
All right. And, should we say, well, your remedy is one that's fictional? Or is it one that they could have told?
No, Your Honor, I'm not arguing that the remedy is fiction. I am arguing as follows, that first off, under the Federal Arbitration Code, there's no case law that directly addresses whether it's told. The Florida Arbitration Code does have a provision that expressly states that in grounds of fraud, that the 90-day period begins to run when the party knew or should have known of that fraud. Here, you don't need to reach that decision because the allegations below, the complaints, including the attachments, show beyond any dispute that the appellants knew about the alleged documents that were allegedly withheld in the first case, and also knew about the alleged nationwide fraud because they filed a separate arbitration claim in June 2006.
There's nothing alleged about it. They were fined $15 million. I don't think that you've answered Judge Evander's question, and I don't think it's an unfair question. Assuming that you're going under the federal statute, and you have a situation where subsequent to 90 days, it is revealed that during the course of the arbitration there had been fraud. There had been hidden emails, emails that were claimed to have been destroyed during the World Trade Center attack. And it turns out that wasn't true, that there was a backup system in place and all the emails actually did exist and hadn't been provided by Morgan Stanley. But you're outside of the 90 days, you're going under the federal statute. Is it told?
Under those circumstances, Your Honor, yes, it may be told.
Yes, it may be told.
It may be told under the federal statute. Again, there's no case law that
you're equivocating on it. When you say it may be told.
Well, Your Honor, the issue would be then the issue in terms of the tolling would be then what standard is the court going to create for tolling? And you're asking me with this particular fact pattern, the response would be yes, it would be told. For other fact patterns, it would be different, and that's the danger that the court faces in creating a new rule. In this case, when it does not have to create such a rule. Here, we don't need to litigate or argue over tolling because the record below is clear that the appellants knew about all the alleged misconduct, and Your Honor, I'll address whether it applies to the appellants or not, in June of 2006. And then subsequently, at the end of 2006, and they litigated the very issues that they raised today in that arbitration.
Did that litigation reach the substantive basis of the claim, or was it disposed of on procedural grounds?
The arbitrators held that their exclusive remedy was to bring a claim under the Federal Arbitration Act. That's what the arbitrators held in the second arbitration.
So it was a procedural, that was resolved on procedural grounds?
It was resolved on procedural grounds.
The merits of the claim were not resolved in the second arbitration action?
No, they were not. The merits of the underlying claims were not. And if Your Honor, if I may address this nationwide discovery issue, there was nothing provided below or alleged in any of the complaints that any emails, other than those 18 pages of documents, were withheld from these claimants. If Your Honor, in terms of the regulatory settlements, they allowed various parties in arbitrations to request emails from Morgan Stanley, and they did not avail themselves of that process. So with respect to the email, the 9/11 email discovery issue, yes, there's a regulatory settlement, but there's no allegation anywhere in this complaint that those types of emails were withheld. The emails or the documents that were allegedly withheld are those approximately 18 pages of documents that counsel obtained in a second case. And, Your Honor, our position is that those documents were not required to be produced in that first arbitration. But again, from a standpoint of this procedure, it's legal. It's legally irrelevant because they were aware of those documents as of October 2005 and did not file a complaint until August of 2008. In the intervening time period, of course, they filed their second arbitration and expressly submitted this dispute, this discovery-based dispute, to arbitration. If I could also address the other issue, as the Court noted, there are no cases that counsel can provide the Court that would result in an exception to the collateral attack doctrine. The reason for that rule is very clear, and I think that the Ninth Circuit had a interesting way and the appropriate way of looking at this, because if the Court is going to allow an exception to the collateral attack doctrine, it will reopen and allow litigation of virtually every arbitration, because as the Court would recognize that in virtually every case, somebody after the fact is going to be unhappy with the result. And is someone then going to argue, well, this document wasn't produced or that document wasn't produced, and then as a result of that, they can go back into court and relitigate whether documents were produced in the underlying arbitration or not, because that's the result that would happen if the Court adopts counsel's requested exception to the collateral attack doctrine. And what the Ninth Circuit ruled in the Sander decision was that this proposition that the appellants espoused before the Court opens up unending collateral attacks and arbitration awards on the grounds that some piece of discovery or another was withheld or improperly represented. We find that quite inappropriate. And the Court then, of course, went on to find that the failure to produce a report in that case did not warrant setting aside the arbitration award. And the only alleged documents here that were not produced, that were presented below, were those 18 or so pages that involved other customers and did not involve the appellants.
It involved the same broker?
It involved the same broker.
You don't think that might be relevant?
Well, again, in the arbitration procedure, there are requests for production and responses, and there was never a motion to compel or an order below. I did not handle the underlying arbitration, so I don't know exactly what happened. All I have is what was in the record, and they never presented any order or requirement that those documents be produced. Apparently, in the second case, there was a request, and they were, in fact, produced in the second case. That's how counsel discovered those. But to get back to the ultimate conclusion here is that the FAA and the Florida Arbitration Code is designed to have very, very limited judicial involvement in arbitrations. The whole purpose, as this Court noted in the Chandra case, and as the Florida Supreme Court noted in the Schumacher case, is to provide a very, very limited grounds to set aside arbitration awards, and they're specified in the statute. And there is, as the Court noted, and as we noted in our paper, a grounds to set aside an arbitration agreement, set aside an arbitration award for fraud. And the case law follows that and rules that if there's any fraud in connection with the arbitration that taints the arbitration award, the exclusive remedy is under the FAA or the analogous provisions of the Florida Arbitration Code to create a new grounds to attack, collaterally attack an arbitration award renders that whole statutory framework irrelevant and meaningless. People could just go around it and file independent claims in court. And let there be no mistake here that what appellants are seeking in terms of their relief. There's been no dispute below, and there's no dispute in the papers. They're seeking to retry the first case. For example, they were candid about it in their papers, that they admit that the purpose of this was to augment the original award, arbitration award. And you don't even need to go accept that alone. But if you look at the elements of their causes of action, or the causes of action that they allege a claim for statutory securities fraud. As we pointed out in our brief, the only type of claim that applies to if there's a purchase or sale of a security. This discovery business is not a purchase or sale of security. They want damages arising from the original recommendation to buy or sell a security. That was what was litigated in the first arbitration award. The bottom line, and the courts have carefully considered this, what they're trying to do is they're trying to augment, they want to go back and augment the first award. They did get an award for $50,000 in that case, and they want more by the argument that but for the production of these 18 pages and those are the only documents that they have pointed out, the award would have been higher. That's their theory. And that's the theory that falls directly within the impermissible collateral attack doctrine. That's what they're asking this court to, that's what they asked the court below to do, and that's what they're asking this court to do here. And there's no authority. The authority is to the contrary. Thank you.
How much time is left, Your Honor?
You have almost just under 7 minutes, 6 minutes, 50 seconds.
Thank you. You focused on that second arbitration, which was dismissed on the very grounds they argued that you didn't avail yourself within basically the 90 days, and of course there was no time to do that. They're talking about delay, but they haven't even raised the statute of limitations, and any statute would long be told because we were always fighting. The second arbitration took nearly a year to get decided. We even filed a petition with the NASD, the very regulator of this business, and they wouldn't talk to us until one of the senators wrote them a letter, and then they called. They never put a piece of paper on the record and said, we don't have to do anything with your petition. So, all right. So I went to court. The Van Buren arbitration produced about 6 inches of new paper. I only selected 18 pages that had to do with Smathers himself and not just the office. Now, there really is too much talk about opening the floodgates. I don't know how many times over the course of a year a panel will hear the floodgates argument. The diocese didn't open any floodgates. This won't open any floodgates, but when you get a nationwide fraud, a disaster like the World Trade Center, and say everything was destroyed, and it wasn't until after Van Buren was settled, I don't think it had anything to do with that, that they began sending out letters from the General Counsel's office. Well, we may have found some emails.
It's not that we're not sympathetic to your client's position. What we're really addressing here are just the legal issues of what path needed to be taken to try to address the issues that came up once the fraud was discovered. Whether you could do a second arbitration, whether you could file an independent action, or whether your remedy was to go back and move to vacate the earlier arbitration based upon an allegation of fraud. That's the issue that we're dealing with. It's not as if we're not, I don't think, concerned about the overwhelming impact of any decision that we might render here, and nor are we unsympathetic to your client's position. It's a procedural issue.
That's a good
start. At least from my perspective.
Well, then I think what we don't want to have happen is a gotcha situation. We tried opening up by the second arbitration.
Did you ever file a motion to vacate the first arbitration?
In my mind, that's basically what we did with that second arbitration.
No.
It may not have said motion to vacate.
But the ruling of the second arbitration was you need to go and file a motion to vacate the first arbitration.
Yeah, but
did you do that after the second arbitration?
you're past the 90 days.
Well, you were past 90 days at the time that you learned of the fraud.
Absolutely.
And so either there's a tolling or there isn't a tolling, The only way to find that out is to file a motion to vacate the arbitration award and get a ruling on it.
Well,
But that's not the path that you elected to proceed under.
I certainly can do that upon remand, but then we'll be back before industry arbitration, and unless a court says that tolling is a valid method, then we'll be right back here. That's the problem. They
You
don't...
understand, Mr. Dyer, that issue is not before us. What's before us now is whether you can file an independent action, period, as opposed to that your remedy would have been to go back and attempt to vacate the initial arbitration award. We only rule upon those items that are before us, and we rule as narrowly as possible. And we can't make a ruling at this point as to whether, A, there would have been a tolling or wouldn't have been a tolling, and B, whether whether the statute, whether you still have any right to do that. You picked the path, and we are now dealing with those choices.
But whatever choice you make, if it goes back to a panel arbitration, the wrong has to fit in that arbitration agreement. It didn't fit in diocese, and if you can't make it fit, then it's an independent action. That's the way we see it.
All right.
Thank you.
Thanks, sir.